now, every citizen who is qualified to vote for the National Assembly is eligible to be a member of the Assembly, except, quote, anyone who is convicted of an offence and is sentenced to more than 12 months imprisonment without the option of a fine, either in the Republic or outside the Republic, if the conduct constituting an offence would have been an offence in the Republic. Essentially, that's what Section 47 of the South African Constitution says. And on that reading, it is clear that the convicted criminal, Jacob Zuma, cannot run for office to be a member of parliament and certainly not the presidency. This is why the Independent Electoral Commission removed his name at the top of the candidates list of the uMkhonto Wesizwe party. But the MKP says it will now approach the Electoral Court to review that decision because it believes, amongst other reasons, that the IEC does not have that mandate. We're joined firstly by Nhlamulo Ndhlela, who is the uMkhonto Wesizwe spokesperson, but also Mpumelelo Zikalala, who's a legal analyst, who'll weigh in on the merits of their arguments. Let's start with Nhlamulo Ndhlela. Thank you so much for your time and welcome to 702 Breakfast.
Thank you, Bongani, and good morning to your listeners.
So do you accept that the IEC is the statutory body that is meant to run these elections?
I do accept, but I do not accept you labeling President Zuma as a criminal.
He is a convicted criminal as far as that is concerned. I mean, that's a fact. So that's not even a matter of opinion. But let's get back to the issue at hand. What is your objection to the IEC removing his name from the candidates list of your party?
Well, the first point, Bongani, which we need to make clear is that on or around the 24th of January, Commissioner Janet Love made pronouncements that President Zuma at that point was not eligible to be on the candidate list, and such pronouncements being made without a proper process being followed, neither an objection being submitted. Now, the same Janet Love, as a commissioner, sits in a commission to have oversight in terms of a decision that was made to uphold the same objection that was put forward. What is concerning is that by virtue of her making those pronouncements in January and then presiding over the upholding of an objection, in of itself is a conflict of interest, and she ought to, number one, have recused herself. Just as is the case with the other judge, that recused herself.
Nhlamulo, as I recall, Janet Love made a statement broadly speaking about who was ineligible or eligible to run for office. But even if you specify it to Jacob Zuma,
she stated Jacob Zuma.
Sure.
So by virtue of that, she stated.
Hold on,
Nhlamulo,
can I explain what I mean?
I'm listening.
I'm saying to you, as I recall it, Janet Love made a broad statement. But even if you specify it to the person of Jacob Zuma, it would have been specific because there are issues that pertain to him. This is a person who was sentenced to 15 months by the Constitutional Court. And even when he was given medical parole, that was set aside. The only reason he did not spend that 15 months behind bars was because of the president's remission of his sentence.
I think you're watering down the situation and the gravitas of the situation of what. In saying so, she stated that President Zuma will not be eligible to be on the candidate list. But in any case, let's move on to the issue of remission. The Act, as you eloquently put it, refers to 12 months without an option of a fine. That's correct. However, in President Zuma's case, upon serving 3 months, at the point at which he was serving 3 months of his sentence, the president of the country then issued a remission, which then states that the term at which he has served of his sentence, which is 3 months, then becomes the total term of his imprisonment, his sentence. So in effect, what that remission then means is that President Zuma now does not fall within the ambit of the Act that refers to 12 months or more without an option of a fine, because effectively President Zuma would have served 3 months. because the rest of the 12 months then gets, in effect, erased from his sentence.
Nhlamulo,
President Zuma
Section 47 does not talk about how long a person is in fact behind the bars. It says, hold on, it says a person who is convicted of an offense and sentenced to more than 12 months. It doesn't specify how long they may serve that sentence. The fact that it is given is enough to disqualify him, and that's clear.
Yes, but the IEC is acting outside of its jurisdiction. Section 47(1)(e) is that of the National Assembly as it pertains to the fitness of a member of parliament to stand, not the IEC. The IEC is overreaching here. It's not upon them or within their jurisdiction to invoke Section 47(1)(e). And that's the point we're making here. So your reading of the law, unfortunately, is skewed.
I started this interview by asking you if you accepted that it is the mandate of the IEC to run these elections. This is not just a matter of a rule of parliament. It's quite clear in the Constitution, as I've outlined, but also the IEC runs the elections. It is surely up to them and their mandate to decide, based on the law, who may or may not contest those elections in the first instance.
I'm glad you're referring to the law. Essentially, you mean that they're not a law unto themselves. It's them overreaching. They're encroaching in a jurisdiction that is not theirs. It is the National Assembly, off the back of a constitution that the same draws its act from, the same constitution, that has given the powers in terms of Section 47(1)(e) to the National Assembly to make that determination.
No. You can't have criminals run for elections and then leave it up to Parliament to decide whether or not, in fact, they should have been allowed. Your argument doesn't hold water.
It's not an argument; it's a fact. Read the law. Maybe you should have studied and gotten some consultation prior to this.
All right, Nhlamulo.
I think you're misinterpreting the law here and misguiding the listeners.
What happens if?
Okay, I'm listening to you. Go ahead.
What happens if you don't get your way?
Well, if we don't get our way, which is something that we doubt, we'll make a determination at that point in time.
Do you stand by comments such as those made by Bongani Bingwa, your youth leader, threatening unrest should Zuma's name be removed from the ballot?
Bongani Bingwa was totally out of order, and we've dealt with that. We've given him a warning, and I want to also state categorically of uMkhonto Wesizwe that utters or makes any pronouncements of violence, they will be dealt with drastically and will expel them.
Have you expelled Wesizwe Reddy?
Well, Wesizwe Reddy, in the same way we've dealt with Bongani, has also received a warning.
He's in fact being charged by the NPA for threatening violence for this election.
Indeed, we're aware of that. Let the law take its course. But also, the law ought to apply equally. If the NPA can move so swiftly, they must not forget to move as swiftly when it comes to Phala Phala. In terms of the money that were found.
This is apples and oranges. This is apples and oranges, Nhlamulo.
No.
Here's the point, and the reason for our conversation is that some of the supporters of Jacob Zuma may indeed feel aggrieved. And how concerned are you that they may act on those grievances? I've mentioned Bongani Bingwa, I've mentioned Wesizwe Reddy. These aren't just some of, this isn't just comments of loose cannons. They may well give effect to those sentiments.
If you allow me to finish off before badgering Bongani, we can have a constructive. In any case, let's get on with your point. As I've stated, as it pertains to Bongani Bingwa and President, I've clarified that matter. And any other person, party, that aims to incite violence or demonstrates by virtue of their comments any level of political intolerance, we will not tolerate political intolerance. And we need to be very clear on that. We will, as I've said again, as I'm going to say again, act drastically by way of expelling them. Because we cannot associate ourselves. Look, here's the reality. We are losing a member every week to murder. I don't hear any news outlet reporting on that. And these are patriotic South Africans that want to see change, and by virtue of them associating with the party and wearing regalia, they get murdered. Do you report on that, Bongani? No. Do you even touch on that? No. But yet, uMkhonto Wesizwe wants to always be labeled, people want to always label uMkhonto Wesizwe as a party that is violent.
Nhlamulo Ndhlela is the spokesperson for uMkhonto Wesizwe. Listening to that is the legal analyst Mpumelelo Zikalala. Thank you so much for your time and your patience. The essential reason we are talking, in the context of everything that you've just heard, this refrain, Wenzeni uZuma, what has Zuma done? This is the ultimate grievance slogan. How concerned are you that all of this isn't just courting controversy, but indeed the disgruntled supporters of MKP or Jacob Zuma could act on that sense of grievance?
I think the utterances which are going to be stated by the leaders are indeed concerning. When you listen to a leader of a political party, you certainly take that as something which the political party is indeed discussing behind closed doors and it should be concerning. However, if a political party is going to come out then and say we are distancing ourselves from these two individuals, then action must be taken in those individuals, and a statement which is contrary to what has been stated earlier must then be made public. Adherence to the code of conduct of the IEC is ultimate importance. Adherence to the rule of law when it comes to things that are pertaining to voting are also very important. So it's important that political parties, for a lack of a better word, behave, and they hold accountable those who are going to misbehave and make sure that their misconduct is put out there in the public, and it is not at all concerned or mixed up with the principles of the political party. If that doesn't happen, I think it says something about them to the electorate.
Does MKP have a case here in terms of the IEC's jurisdiction to rule on this? And also this issue of the remission of the sentence. The Constitution, in my reading, talks about how long a person will be sentenced rather than how much they serve.
On the ability to take that particular decision, I do not think so, even though where they may have a point is within the responding to the objection that is there. Remember, whenever a government, the department, or any person who is in power takes a decision which is going to be arbitrary to you, or someone has made an objection, you deserve the right of reply. The ad atom party rule then comes into play. So if an objection has been made, then the next thing that you should do is to say to the former president, here's an objection that has been made against your name. What is your response pertaining to the things which have been alleged? Because as the IEC, we are not in the business of doing investigations into criminal records of individuals. Is there an explanation that you can come up with here? And if it is, we'll then consider this, the submission of the objector and your submissions, and then come to a conclusion at the end of the day. If that has not been complied with, that there may be non-compliance with the law in certain instances.
Even if it is a matter of record or a matter of fact that indeed he was convicted and sentenced?
For compliance purposes, it would need to be done so that there's a proper record that says, as a government institution or an organ of state, this is how we arrived at this conclusion. We can't be presumptuous. We have to deal with things which are going to be stated on the table so that you can be able to go and argue it. And it also prevents a situation in which we are finding now, in which you go to court so that you can be able to explain or deal with the objections that would have been raised in-house, for a lack of a better word, before dealing with them in court. Because what then needs to come into effect is, what is the effect of the remission when it comes to one sentence? And a distinction must be made between a parole, between a pardoning, and between a remission. A remission basically is saying, we are going to take away certain months or a period of your sentence is going to be removed, and by virtue of that removal, it would mean then, one may argue that it means you're going to serve a lesser sentence. If that's the case, then what is the date or what is the conviction period in which I was convicted with? Does that have an impact at all? And I think the court is the only individual that should be able to determine this for us.
Mpumelelo Zikalala, legal analyst, appreciate your time. There it is. Certainly, it's all as clear as mud.
Current events, developing stories,
tough questions.
Your voice making a difference.
This is Breakfast with Bongani Bingwa.